So that's the process of witness examination. I'm also going to talk about the manner of the cross questions. I am going to demonstrate for them how tough it is to get short, bite-sized questions like we teach. Questions that are driven to yes. You have a car, right? They're not used to having conversations like, yeah, right? That's their answers. Like, come on, prepare them for the manner of those questions. They're not going to ask you if you drove the white car that went through the intersection at the red light at Mission and First. They're not going to jump to that end question. You have a car, you were driving on this day, your car is white, you went up to this intersection, that's the specific intersection that you've been to before. Teach them about the manner of those questions. Teach them about the process by which leading questions come out. Be patient, turn and answer, right? You want to show them what that process is going to be like so they can confidently make their way through it. Next, I like to say, and I say this to attorneys all the time, and I say this to law students all the time, the jury is looking to figure out, not necessarily by the content, not by the words that are on the transcript, they're looking at human factors, expressions, body language, to see how this whole thing is going. So I tell advocates all the time, no matter how it's going, you better appear that that's exactly how you planned it, right? If I'm giving a cross-examination, then no matter how far it goes off the rails, I better be looking like this is exactly how I intended it to go. Well, same goes for your witness, right? Picture the body language, the human dynamic, the expressions that can come from your witness if you don't prepare them. If all of a sudden, properly on cross-examination, their credibility is challenged, and properly on cross-examination, their credibility is challenged under some specific rule, like 608B, and they start asking questions about a law school application 10 years ago, and a specific question that has to do with marijuana use, picture if they're not prepared what that body language is going to look like. Picture that witness's expression when they get that question. It's going to be, holy God, I can't believe they can ask about this. Then who do you think they're going to look to in the courtroom? You. They're going to give one of those, like, do I have to answer this? Oh my God, please help me, right? All the body language, all the expressions is all bad. So I have to prepare them, like, you want this cross-examination, you want this witness examination to go well, you want to get up on the stand and then get off and get back to your life, then this is what you do. No matter what happens, you keep the air of that's exactly the way we planned it and that's exactly the way we talked about it. I'm going to try to plan with you every contingency. You're going to know about my whole direct examination. You're going to know the likely areas of cross-examination. I'm going to show you about the process. I'm going to show you the manner, right? But even if there's something we didn't cover, you, with your body language, you, with your expressions, keep to it because they're looking at you to see how it's going. And guess what? We don't want it to be going well, so show me your best game face. You can imagine when I'm prepping some expert witness that's done this 30 times, right? And I'm 30-something years old, and I look at him and I go, show me your best game face. I have some, forensic psychologist looking at me like, I don't have a game face. What do you mean? Yeah, you're right, you don't. That sucks, and let's fix it, right? So that's what we have to do. You actually work through these things and show me what it's supposed to look like. The last one, and this is my favorite one, is as it relates to credibility, you have to understand, with this, some things we can do. We can do background checks on our own witnesses. When you work for the government, you have your investigators run background checks on everyone. I can know about prior convictions, one rule, but I can't know about all the dirt that you have in your life that you could potentially be crossed on. Especially if the other side has launched into an investigation. Especially if the other side has the benefit of those that aren't thrilled with you right now on the other side of the lawsuit, right? So you have to help me help you, right? And this should channel your inner Tom Cruise, Cuba Gooding Jr., right? This is the help me help you, right? I actually want to sit there with my witness and go, please, assume that they're going to find out everything. Tell me the worst news. Tell me what would horrify you the most that would come out on cross-examination, and we'll work through it, right? And then what happens? You're going to go through some stuff. I might even tell them some examples of some things that can come up as credibility challenges, like the law school application, like the question about marijuana use. I'm going to go through that stuff. These are examples. They might be able to get into them. Tell me now, so that way we can prepare for it. If I don't know about it, then not only is it going to be something where I have to keep on my game face, but so will you, because we couldn't have prepared, because you didn't help me help you, right? And you will get some weird stuff. You will have your witness come to you and say, all right, I understand. I understand how this works now. I have to help you, help me. I understand. It was senior year, it was a band concert, and I streaked across that field. And I get to go, that has nothing to do with anything that's going to come up in witness testimony whatsoever. But I'm really glad you told me. That's a good example of you being forthcoming, and now me, as the lawyer, can say, doesn't have any bearing on your credibility, it's just thanks for telling, right? So that's what you want to do. All right, the other things that are going to come out, the way you have to think about it is that every witness, almost every witness, will have lots of facts favorable to you. It's the reason you called them. If they don't have enough facts favorable to you, you're going to ask yourself, why are you calling them? But they'll also have favorable facts for the opposition. Every witness has got a little bit for your side or a lot of it for your side, but they always have something that will help, even an interpretation of something that will help. And you'll see that in our demonstration today. There's a reason why I call this witness. It happens to be the plaintiff. There's a reason why I'm putting on their testimony. I have to put on what happened to them, the damages that they have, what went on. I need them to establish my case, but there's questions that the other side can ask that are favorable to their side, their theories, and their case. It just so happens. So you have to prepare them that, see that fact right there, Mr. Witness, Miss Witness, that could be spun. I can ask it, and it means this in our conversation, our scripted conversation. On cross-examination, if they're asking about it, could mean something totally different, and here's the way, the manner that they're going to ask questions about it. The next thing I prepare them is for tricks and traps. I let them know the ways that things can come up and how it can go on cross-examination to be this disjointed presentation of information. So think about it. I want to actually cover and take specifics from their case and say, watch, let's go through this. So we have something like that in our hypothetical as well. The person, the plaintiff in the case who was assaulted, and we're going to hear about the more specifics as they come, right? He was assaulted. He also happened to be drinking that night. Through cross-examination, drinking at a given establishment, let's say it's 4th Street Grill, right up here on 4th and Mission, right? Drinking at a place, I can ask questions in cross-examination in that manner of leading questions that can make it seem like you had a lot more to drink than maybe you actually did. I can talk about the size of the glasses, how the waitresses operate with asking you what's the deferred mechanism when they come over and say, would you like another beer? I can go through all of these different things to really open up the range and make the process of cross-examination favor my case. Some of it's a trick, some of it's a trap, some of it is just a manner that I'm going to leave things open and vague with the witness, so when the witness leaves the building, and they leave on an airplane and leave in a cab, I stand up in closing and I argue that they were drunk. I don't even have to have them agree with me. So I want to go through, again, specific facts from their case and show them how that can work, and show them how they should handle it, and show them how they maintain their game face during. The next one that I like is I like to scroll through what those credibility challenges. So as much as I want you to help me help you, and you come up with streaking or you come up with a law school application, I need to tell you how some of these rules work. I don't need to go all evidence on them and start telling them about 609A1, but I do need to tell them, have you ever been in trouble? Have you ever been convicted? Even if it's a misdemeanor, it might have something to do with credibility, and that might be something they can use on cross-examination. Tell me the stuff. Tell me what's out there. I'll go through the rules and the avenues, but you're the one that have to tell me the stuff. This is help me help you, but I can help them in the first instance by telling them what the rules and the normal mechanisms. Try to explain to a witness, you have to explain to a witness, what bias is. Bias is not in the federal rules, but the other side, on cross-examination, can explore any reasons, any motivation for your testimony, right? So if you settled early, or if you know one of the parties, or you were dating a witness from the other side, all that stuff can be in bounds and can be under the umbrella of bias. I need to explain that to my witness, and I need to bring that out to have them help me, help them about bias and other credibility challenges. And lastly, they need to understand, I talk to them about the parts of examination. I talk to them about direct and then cross and then redirect and how it all funnels down within the scope, right? They need to understand that there are just certain times when the opportunity to explain is going to be when I'm asking the questions. That's exactly how I said it, right? You can do some leading questions, right? You can get a bunch of yeses in a row. They can feel confined, but imagine, again, you got people from the public, you got people in the jury that are watching. If you're trying to talk over the questioner, if you're trying to offer explanations where the question doesn't call for it, you start to look defensive. If the question calls for a yes, you own a car, give them a yes. And if there's an explanation that'll come through me, and it'll come through redirect. You have to have confidence in me as the attorney to know what's appropriate for redirect, what's the level of questions that are appropriate for redirect, but that's what I get paid for. That's why I'm your counsel. I figured that out. Don't try to do it on your own because it just looks weaselly, it just looks defensive. Get a question that's leading, calls for a yes, clearly calls for a yes, turn to the jury, take a pause, say yes. Look back at the questioner, right? Look confident, keep your game face on and answer the questions posed to you. Know that if there's a big explanation to come, or if there's some sort of issue that's now confused before the jury, or that was presented in a slimy, unclear way, I am going to cure that. I am going to clear that up. And the timing, the time for it, is redirect.